Are we live?
Yeah.
Hi, everyone. Thanks for joining our live stream today. I did want to talk a little bit about EB-1A profile building, and we'll cover a bunch of topics. So if you have questions and want to cover a specific topic, feel free to post a question. The very first thing I wanted to cover, though, is EB-1A is not the only goal. I have talked with a lot of people recently, and usually they're younger in their career. So they've been here in the US for maybe a couple years on H-1B. They see the perm backlog, they don't have an I-140 approved, and they're like, okay, EB-1A is the only way that I will reasonably get a green card. And that is true. So EB-1A should be the ultimate goal for a lot of you if you're stuck in this position, but it is not the only goal. A lot of you in this position are going to be a couple years away from being able to file an EB-1A. 2 to 3 years is normal, but also 5+ years is normal. Some people need 10+ years to qualify for the EB-1A. It's not something that everyone can just do. It does require depth of expertise, real contribution, real acclaim, and setting yourself up as a top professional in your field. And that can take time, even if you are working every day towards that goal. So even though the EB-1A can be an ultimate goal, it's important that it's not the only goal. You have to take care of yourself along the way and make sure that you can actually work in the United States and that you're setting yourself up for success in the future when you do get the EB-1A. For anyone who is at least 6 months away from filing an EB-1A and doesn't yet have a priority date, I'm going to recommend that all of you look at perm and look at EB-2NIW. Look at a way to get an earlier priority date. If you put everything on EB-1A and you end up filing your EB-1A 3 years from now, the backlog isn't just going to be 3 years, right? The backlog is ever growing. So that 3 years of time might mean 10 years of a backlog. And so every day you're not getting a priority date, you are putting yourself behind in the ultimate backlog. So you might think perm is 2.5 years. I don't even know if I'm staying with my employer for the next 2.5 years. It's such a hassle. It's not in line with my personal goals. Still do it. Take your employer up on it. Push your employer to file for a perm. The earlier you can get a priority date in the system, the better. And sure, you may end up moving jobs or getting laid off or changing careers or doing something else along the way that would interrupt that perm process. So it may be wasted effort in the end, but you don't want to get 3 years down with your current employer and wish that you had started perm 2.5 years ago. You should always take the opportunities as they come. And for most people, perm is still the way they get their priority date. For anyone who's not born in India, perm is still the normal way to get a green card in the end. So don't put everything on EB-1A. EB-1A is an ultimate goal. It's something that you should be aware of. It's something that you should consider. But get the priority date as early as possible. Take care of yourself along the way. Make sure that you are opening up multiple pathways and multiple options for yourself. And I do think it's important to know perm is the traditional way to get an employment-based green card. And so there's nothing wrong with pursuing that traditional pathway. And in fact, if there's an opportunity for you to do it, you should take it, even if you are pursuing other things on the side. And then just a quick consideration and a plug for EB-2NIW as well. Some of you don't qualify for EB-2NIW yet, maybe because you don't have 5 years of experience and you just have the bachelor's degree. So yes, you can look at EB-1A, but eventually you will get 5 years of experience post-bachelor's. So you should potentially look at doing an EB-2NIW for yourself as well. And then for anyone who's not born in India, EB-2NIW is a great way to immigrate to the US through the employment-based process. You don't need the EB-1A. If you qualify for EB-1A, that's fantastic, but a lot of you will need 2 or 3 years of profile building on the EB-1A. But if you're qualified and you can file the NIW in 6 months, the EB-2NIW might be the way that you immigrate to the US anyways. You may not need that EB-1A in the end. So look at both, pursue the EB-1A definitely, because you don't know what's going to happen with the EB-2 backlog. But take getting the earlier priority date seriously. It will help you immensely. And, For Indian nationals, the difference between filing, 3 years from now might mean 10, 20 years of additional backlog. For you, it still means some additional time. Like the EB-2 backlog is also growing. So if you get a priority date and you're able to secure that within 6 months, if you were later to secure a priority date, in EB-1A a year from now, there might be some retrogression. So there might actually be a backlog in the EB-1A category. You don't actually know what's going to come in the future. So yeah, just my 2 cents. Take advantage of the opportunities that come to you. Don't get laser focused on EB-1A. Like I am not a subscriber in going forward with no backup plans. I think it's a disaster. In immigration, you want as many backup plans as possible. You want as much support so that if something falls through or gets denied, or even wrongfully gets denied or gets denied due to some administrative error, you want those backup options in place. So still pay attention to your company's perm program. Still go through that process. It like I keep repeating myself, but I can't emphasize that enough. It's very important for you to take advantage of those opportunities. All right, we can come into some case questions here, and then I'll talk about other EB-1A profile building topics. Jason, I think there's a few questions.
Do you help with international entrepreneur rule applications?
So I think you're talking about the entrepreneur parole applications. Yes, I can definitely help with them, and I can definitely file them. I'm familiar with the laws and the rules and all of that. I will say I have never filed one. And the reason for that is there's almost always a better option for somebody. I would file entrepreneur parole kind of as a last-ditch option. But very, very few people end up filing them. Most people have an alternative visa category that they can go for. And the reason to go for an alternative visa category is that it confers actual real status, whereas parole is kind of this pseudo status. It's very difficult to transfer out of that status to get other visa types and ultimately to get your green card. So other visas are almost always better if you have options for them. But yeah, if entrepreneur parole is the right fit for you, I can definitely file those cases. I filed a lot of similar types of cases, even if I haven't done an actual entrepreneur parole case, and I'm very comfortable with it. I would just probably advise you differently.
Are you seeing an increase in the NTA cases? Are you suggesting to leave country during the grace period to avoid NTA during the grace period?
So I'm not necessarily seeing an increase in NTA cases. There were a bunch of NTAs issued that have caused a huge buzz, in the legal community, and a lot of attorneys are talking about them back and forth. I've only seen a couple and none for pre-existing clients. I generally don't suggest leaving the country during the grace period just to avoid the NTA. Part of the reason for that is the NTA is sent via mail, so you don't ever want to be in a situation where the NTA is issued, you leave the US the next day without knowing that it's issued, and then all of a sudden you're called to be in immigration court and you can't get back into the country to actually attend that hearing. That's almost worst case scenario there. And that's why the government hasn't traditionally made people a deportation priority the day after they lose status. Traditionally, the government was reasonable, and if someone suddenly lost status, they would allow the person a couple of months to wrap up their affairs and leave the US. Yes, you don't have status during those couple of months, but it's only reasonable that you would need to pack up your belongings, buy a plane ticket, say goodbye to your family and your friends, and all of that. So the whole thing is just a bunch of nonsense, and I don't anticipate that this particular scenario will increase substantially. I think the government is just kind of testing it out and seeing what happens, basically just intentionally causing a lot of chaos. I will say the law doesn't impose significant penalties on unlawful presence until you reach 180 days of unlawful presence. And again, that's because I think the law recognizes that people can and do lose status very suddenly and wouldn't necessarily have the opportunity to buy a plane ticket the very next day and leave and move their entire life the very next day. So you should know that If you get laid off, leaving during the grace period is certainly an option. It's not an option you should discount. A lot of people do leave during the grace period and then they pick up their job search while they're abroad. It's a good option. It's a valid option. And it's right for a lot of people. It's also totally the wrong option for a lot of people. And so I'm still recommending that people file their I-539s for a change of status, either to H4 or L2 or some dependent status, or to B2 visitor status. It's not a guarantee that an NTA won't be issued, but it is properly done. Like, there is a grace period, it's acknowledged in the law, and yes, USCIS has discretion on whether or not to apply the grace period, but filing the I-539 is at least proper. There's a mechanism to do that in the law. So it's fine to file the change of status. It's also fine to file a new I-129, or have your employer rather file the new I-129 and the new H-1B sponsorship to start during the 60-day grace period. What I am suggesting is that you communicate with your prior employer, that you understand when they are going to notify USCIS of the layoff, and that you try to negotiate your severance package so that you can stay on as a non-productive employee for a lot of your 60-day grace period. Then that gives you time to file the I-539, time to do some job searching. They essentially keep you on payroll, but your severance is being paid out as normal payroll. That seems to be the best option for a lot of people. And I recommend that you just talk with your employer and try to negotiate that best case scenario. It's a tough situation. And honestly, it is totally a bunch of nonsense. It's clogging up the immigration courts. It's ridiculous because all of these people have valid options for either regaining status or for leaving the US within a grace period, which should not incur any kind of unlawful presence, accrual or penalty or anything. It's just ridiculous. Yeah.
You're laid off on H-1B. What do you suggest as steps to self-file H-1B for a startup employer where one is an important stakeholder?
So if you're laid off and your plan is to go work for your own company, the process is almost the same as having a new employer sponsor you for H-1B. If you're an important stakeholder in the company, you're still allowed to use that company to file for H-1B for you. But as far as the steps, it really depends on how far along in development the company is. Like, if it's a brand new startup, you have a lot to do to get in good enough shape where you're ready to file the H-1B petition. But if it's already an established company and you're a shareholder or stakeholder, they should be able to really seamlessly do an H-1B filing for you. I'll also just mention on that, I haven't seen a lot of results come through on the beneficiary owner H-1Bs. I filed my first one. We got a really weird RFE. It was really easy to respond to, so we responded within just a few days. And we're waiting for the results on that case. The RFE definitely made me think that USCIS was not familiar with a startup scenario for H-1Bs at all, which always makes me nervous. I never want to put a case in the hands of an inexperienced officer who hasn't seen the scenario before, because they're more likely to try to find a reason to deny, even if that reason is wrong. But hopefully the case goes through. It certainly meets all of the legal requirements. We'll see what happens there.
For EB-1, what would be considered a high salary, above or below $200K for a semiconductor electronics engineer in the Bay Area, based upon your past experience or interactions?
Yeah, so I haven't looked up the electronics engineer SOC code wage data recently. I have the software engineer stuff memorized, and 200K is not enough for a software engineer. You do need to make more in the Bay Area. Electronics engineer is going to be a lower salary than software engineer, so maybe 200K would work. But you need to look up the Bureau of Labor Statistics data. Usually I'm looking up the state data and the national data. I'm not really looking up for the specific commuting area. USCIS doesn't seem to like it when the surveys are that granular and focused on a city rather than a state, but they routinely accept the state and the national data. USCIS has access to some of the new 2025 data, but the Bureau of Labor Statistics has not yet put out the reports for the 2025 data. They do have reports for the 2024 data. So you're able to use the Bureau of Labor Statistics online search tools to identify what the California 90th percentile salary would be for this SOC code. And I recommend that you do the benchmarking based on that. It's not everything. So you can still make a high salary argument with or without the Bureau of Labor Statistics data, but USCIS does seem to routinely accept it. And so if you can show above the 90th percentile for that, you're more than halfway there to proving the high salary argument. So it's just a useful overall benchmark to use. It's pretty easy to look up, and that's why I recommend proceeding that way.
Can someone who is in community development field file for an EB-1A?
So anyone in any field can file for an EB-1A. I'm not too familiar with community development. Would it be more like urban planning or social work focused or something like that? But I filed EB-1As for people in both of those fields, for example, urban planning, social work. I filed for civil rights lawyer. Let me think what else might be parallel or relevant. A bunch of professors and researchers on researching very specific things related to sociology, like very specific subtopics. Any field can qualify for EB-1A as long as you show that you are a top professional in that field and that you have received significant acclaims and sustained acclaim for your work in that field.
Is EB-1 India and China will not be able to move ever? The porting is equal to the amount of visas billed? Are the rumors true, or is it going to take 10 years to move just a year for PD after 2022?
Yeah, the problem is we don't really know. The data is not it's not collected in a way where the government can accurately predict the movement on the backlogs. And that's because there are so many moving pieces. Some people will have an EB3, an EB2, an EB-1A, and then 2 more EB2 approvals. And I think the way the data is collected, all of those would be considered in the backlog, even though it's just one person and they're ultimately going to use one. Additionally, data on the family members is not accurately collected, and family members are counted against the quota. So there's just a bunch of data points, a bunch of visa numbers that are not accounted for when the government is releasing its numbers to try to predict what will be coming up in the visa bulletin. So will it move? Yes. How will it move? We don't really know. So take, for example, the EB-1 China category. It tends to move up and down quite a bit. India tends to get more and more and more backlogged the more you look at things. I'm not sure if India EB-1 is going to see that same kind of back and forth movement that China does, but it's possible. I think the main problem with EB-1 India is a lot of professionals have been here in the US for 10, 15, even 20 years and don't have their green cards yet. And they all have EB2 priority dates from 2014, 15, 16. They've been here a very long time. A lot of them are going to be able to prove their extraordinary ability and move into that EB-1 category. So if you are a brand new professional here in the US and you're looking at doing EB-1 for the future, you should definitely expect a larger backlog than it exists today. Definitely. It's not going to be 3 years after you apply for your EB-1. It could well be 10, 20 years after you apply for your EB-1 before that priority date becomes current. So EB-1 is not like a saving category or anything like that. Like honestly, that time has passed, but it's at least better than EB-2. Realistically, the law needs to change for there to be significant forward movement. And there has been momentum to change the law in the past as far as the way these kinds of visas are allocated. There's been moves to remove the per country cap so that it's more fairly distributed, where each person is treated the same in the cap rather than each country being treated the same in the cap. So there could be progress on that. USCIS, or not USCIS, sorry, the US Congress hasn't changed its quota numbers since the early 90s. So it's been 30 years since we've had any kind of meaningful change or immigration reform or anything like that. So the law is definitely due to change. The law will change at some point. So when you're looking into the future, setting yourself up for the best possible pathway, you should look at EB-1. But realistically, the law will have to change in order for you to get your green card within a reasonable amount of time. I wouldn't take too much stock in all the rumors as far as using rumors to actually predict when your priority date will become current. In general, though, it is good to assume that backlogs will get longer. I wouldn't necessarily say like decades longer, but just longer in general. It's a good assumption to make when you're planning out for the rest of your life.
Sorry, to continue the question further regarding rumors, are the notice of intent to deny actually happening as reported last month by some firms?
Certainly some of them have been issued. It's not like this is a huge trend or a flood of these are happening. So I think that the fact that one firm reported a NOID issued has caused like mass panic, and it's not a trend. So there's not really a reason for mass panic. Certainly, there will be more of a focus on this kind of thing. The new USCIS director is coming in and really wants to focus the operations of USCIS on enforcement and on fraud investigations and those kinds of things. So, if anyone on this call was involved with something that could potentially be considered fraud, you should maybe talk to an attorney about that. Just to get ahead of the situation. There is such thing as making affirmative disclosures, and if you were in a situation that's bad enough, you may want to ask USCIS to revoke your own I-140 and then apply for it in the future. Like, I haven't recommended that to anybody yet. I'm just throwing it out there kind of as a crazy example. But there are things you can do. So if you have committed some kind of misrepresentation or fraud, talk to an attorney now. But I more often talk to people who are like, will USCIS accuse me of misrepresentation or fraud when they have not committed anything, like they've not done anything wrong. They've not done anything that could be considered misrepresentation or fraud, aside from publishing in a couple of very low quality journals that tend to take whatever submissions are put to them. And that's not fraud. It's low quality. It doesn't really support their EB-1A case very well. But it's not something that they need to like really worry about. So yeah, it's very overblown. Basically, you should be worried if you did something wrong. So talk to an attorney. But if you did not do anything wrong, you should not be panicked or worried about this at all. Like, this is not a mass trend. And it looks like USCIS is being somewhat reasonable when they do issue the NOIDs or the NOIRs. Like, they're at least questioning the right things. So I have some faith in the agency here, and I think the panic is way overblown.
Do I have a peer review publication? Can I use a white paper by published for the major media for authorship criterion for the EB-1A since I am not in the research field?
So the white paper, it has to be published. You said you published it with major media. I would have to take a look at this in more detail. It has to be considered a scholarly work. And some white papers do count as scholarly works. I've especially done this in the context where the white paper is published by a professional organization, kind of as a best practice guide or something that, or a resource that they're referring all of their professional membership to. So it can work in that context. But yeah, I'd want to see what the major media is to see how strong the argument here would be.
I think Rudy answered this.
Yeah. So for this question, it really depends on how developed the startup is. The steps all flow from that, and startups can be in all kinds of various stages of development. So it's not really about giving general advice here. You'll want to talk specifically about your startup situation and what specifically your startup needs to do.
I have an EB-1B approved with priority date mid-2023. I am more worried about the people hopping up and increasing the backlog to a level where I have to wait decades. Do I have a good chance of EB-1A too?
Yeah, I mean, but keep in mind the people hopping up have also waited decades and they've also proved that they have extraordinary ability. Like people see this as cutting the line, but really you are trying to get ahead of where they are. So it's not cutting the line. And I do want to make that very clear. I do not view that as cutting the line at all. It is all well deserved when people move up into EB-1A. But yeah, you do have to worry about this. So with priority date in mid-2023, if you are from China or India, I would expect a little bit more retrogression. Now, if you are from China and it's 2023, it should still move. So you should reasonably be able to get your green card within a few years. If you are India, I'm much more concerned about this. Like it could be 5 years or more before you get your green card. But yeah, you have a good chance with EB-1B. You could evaluate your case for EB-1A, but EB-1A is not higher priority than EB-1B. All EB-1s are EB-1s. So EB-1A, EB-1B, EB-1C, they're all the same as far as the backlog is concerned. The reason to go for EB-1A is if you want to separate from your employer sponsor. And I do work with a lot of clients who change from EB-1B to EB-1A for that reason, where they don't want to be tied to their employer anymore while they're waiting in the backlog. So yeah, it's possible. You can definitely look into it. But yeah, the backlogs do tend to get a little bit longer. Wait for October's Visa Bulletin. So October's Visa Bulletin should come out around mid-September. That's going to be the most informative for you. The Visa Bulletin in October is always the most informative because it's the one issued at the start of the government's fiscal year when they have the maximum number of immigrant visas available. So hopefully your priority date becomes current in the October Bulletin. If it does, definitely move immediately to file that I-485. All right, and then it looks like the other questions are also repeats.
Yeah.
So we do need to leave the live stream. But thank you everyone for joining. This was very informative. Hopefully you have some encouragement from this, like not encouragement necessarily that you're going to be able to get the green card quickly, but encouragement that everyone is kind of in the same boat. Encouragement that the law will change eventually. So you may not be facing backlogs that are decades. Your backlogs may be a few years. But have some hope. I think that things will change. We're way overdue for a change in the law, and there is some growing political momentum for that. But yeah, all right. Thanks everyone for joining. Have a good day.
Thanks, everyone.